This is Patricia Thompson, and I am an arbitrator and a mediator with JAMS in its Miami office, and I'm a longtime forum fan and member. And I'm pleased to introduce those of you who do not already know her to Deborah Belotti. Deborah chaired the forum a few years ago. Deborah also received the forum's Cornerstone Award in recognition of her service to the construction and legal industry. And she well deserved that award. She got it just this last year. So Deborah practiced construction law for more than 40 years. She was commonly recognized by all the various publications as being a superstar. She is in San Francisco, but practices now with JAMS as a neutral, a mediator and arbitrator nationally. And she's quite an authority, and she's my friend. So we are going to talk in this this is the table talk. It's put on by Division 1 of the forum, which is for both litigation and ADR. And we are going to talk about the theme of inappropriate conduct in mediation. Let me give you a premise. The premise is that neutrals, mediators, owe to all participants in legal proceedings, such as a mediation, diligence, protection against unjust and improper criticism or attack, conduct that may be characterized as uncivil, abrasive, abusive, hostile, or obstructive, impedes the goal of resolving disputes, and also, it in effect denies the parties justice. So we are going to talk about that theme as it applies to mediators and the parties in a mediation. We're going to start by talking about inappropriate conduct by mediators and what you can do about it, and then we'll stop, and I'll take any questions or comments anyone wants to make. If you could please let me know in the chat that you have something you want to mention. I'll call on you at that point. Then we'll move to what you do when the other participants are inappropriately aggressive or bullying, both what the mediator can do and what the parties can do. And then we'll take questions or comments. So let's start. Deb, what are the responsibilities of a mediator concerning a mediation itself, and what type of conduct violates the mediator's responsibilities to the parties?
Thanks, Patricia. Well, mediators are in some states governed by codes of ethics. In other states, they are not. Those of us who mediate through an organization like JAMS or the American Arbitration Association or other organizations also are bound by the codes of ethics or conduct applicable there. But in general, the comments that Patricia read just a minute ago should govern all mediators, whether they're statutorily imposed or whether they're required by any code of ethics of the organizations the mediators are involved with. My view of the mediator's role personally is that the mediator is there very simply to help the parties do what they say they want to do when they come to mediation, which is to try to resolve their dispute in a voluntary process and to avoid future litigation for their clients. That's the for the participants. That's the mediator's goal. I assume, as I do in everything in life, I assume that all mediators come to the mediation process wanting to do the right thing and wanting to assist the parties. I guess I have a couple of overall things that I suggest to people when they're considering a mediator, and we'll get into specific conduct and how you then deal with it. But I find that although parties are often inclined to do a lot of research before they pick an arbitrator, they often don't do research before they pick a mediator. And although mediators can't force you to do anything, can't force the parties and can't force the lawyers, they certainly have a lot of control in a process, and you ought to know background background on that person, and background, I think, just beyond what you're going to find in a bio on a JAMS website or a AAA website. So I encourage people in terms of being able to control how the process goes. I encourage participants to think about whether they should be researching mediators or doing even pre-mediation interviews with the mediators. I've only had it happen a couple of times as a neutral, where somebody asked me if they could talk to me before retaining me to just get my philosophy and my thoughts, but I thought it was a brilliant process. That's the first step in controlling and addressing conduct issues and problem issues, because you get something from interviewing directly the mediator or talking to those who've used the mediators before. The other thing I will say before getting into specific conduct and specific remedies for mediators who maybe go off the rails is I always caution people, and I cautioned myself when I was a practicing lawyer, to not assume bad motives on the mediator's part just because something happens in the mediation that surprises you or that you don't think is right. The mediator may have a bad motive. I don't suggest that all mediators are perfect and all of them have good motives, but most of them do, and most of them are committed to making the process fair and impartial. So with that background, what can come up in a mediation if you're the lawyer or the client that you might see the mediator doing that might cause you concern, and how do you address that? Certainly, I have had the problem as a practicing lawyer, and I try to guard against it as a mediator, of the mediator injecting themselves too early into what I'll call the conclusory part of the process. Suggesting that they know how the case is going to turn out if it's litigated, trying to jump too soon to forcing the parties to particular positions. It's offensive to parties sometimes when you do it. It may not be offensive to the lawyers, but it may be offensive to the principals. So I think good mediators tell the parties at the outset, I can't possibly know your case the way you do. I didn't live it. I haven't studied it. Even if I had studied it, you're steeped in it in a way that I'm not. So I set the guideline to say, don't assume just because I say something that I'm trying to tell you what to do. But what do you do if you're the lawyer or you're the client and you think the mediator is indeed doing that, injecting him or herself into the process and the control of the process too soon? I suggest that you take a stepped approach to that problem and all other problems. You first think about, is this something that is coming from a bad motive on the mediator's part, or is this something that's coming from the mediators not understanding the dynamics in the room? I think it's a good idea for participants, lawyers in particular, to talk to the lawyers in the case before the mediation begins and give them kind of the ground rules they're going to follow. But if the lawyer or the client brings to the attention of the lawyer, I think that mediator's trying to control this and moving too fast and telling us what we should do, I suggest that the lawyer pull the mediator aside, not do it in the public setting in the first instance, but pull the mediator aside at a break or as the mediator is going on to the next room, and simply say, in a diplomatic way, at least at first, this has just happened, and I need to tell you that my client has a little bit of concern about it. The client isn't ready to make the leap that you're trying to make from point A to point Z in the process. So first approach, talk to the mediator, and do it obviously diplomatically, even though the mediator doesn't control what you do. It doesn't make much sense to tick the mediator off from the beginning, because what you may hear from the mediator is, you know what, I'm sorry, moving too fast here. Thanks for letting me know that. I'll try to slow down. And good mediators will then come back into the room in the next caucus and say, now, Mr. So-and-so, Ms. So-and-so, the principals, I want to understand a little bit more about what brought you here and what happened on the project on this, that, or the other, with this, that, or the other problem, so that the mediator you give the mediator the opportunity to rebuild their position. There are other problems that I think are not so easily addressed, and those kind of deal with what I'll call things that people could preserve as perhaps, ignore that if you would please, having mediate the perception in the room or in the dynamics that maybe the mediator is preferring one side to the other, not because the mediator is trying to help with an evaluation of the case, but because the mediator has a prior relationship with the other party or the other lawyer or both. Many times mediators do have repeat cases from the same big corporations or big clients or big participants in the construction process. What happens if you see that, and how do you address it? Again, I'd start with a stepped approach. I would talk to the mediator, and it's very often a good thing to be able to say, my client is perceiving this. You don't necessarily have to take it on as the lawyer, but smart mediators know that the lawyers are perceiving it too. Do you call the mediator out on it directly in a way that suggests that the mediator is really biased? I think you have to be careful about that and how you handle it. But I think being diplomatic has to end at some point. I've been told, and as Patricia and I were talking about this, getting together on this topic and making this presentation, Patricia provided me with some comments she had heard from other people, and she said that she had heard reports that sometimes mediators threaten people, saying, I'm going to let the judge know that you're being difficult in the mediation, or suggesting violating the confidentiality overlay of the mediation process. I confess I've never had that either as a practicing lawyer or as a neutral, but it certainly can happen. And it's also true that although mediators are supposed to observe a complete confidentiality, sometimes they won't. I mean, they see the judge who's handling your case, out at an event, and a stray comment gets made. I think you have to be very careful monitoring those things, which truly can be hurtful, not only to resolution of the case, but hurtful to the overall sanctity of the mediation process, which we all want to observe. Other kinds of conduct that you might find problematic: the mediator attempting to give legal advice or suggesting, I know how this is going to turn out at trial, and you ought to take this settlement because you're never going to do better at trial. You've got all these different problems. How do you deal with those? I think in the same fashion. Patricia is well-schooled in guidelines and rules in the state of Florida and around the country about mediation. Be aware of what guidelines there are in your jurisdiction. You might be surprised to find out that there are state laws governing what a mediator can do and setting an ethical standard for mediators. It's a good idea to know that, because you can, if you're dealing with a difficult mediator, somebody who you feel is kind of going off the rails, you can say to them, I'm concerned that you're deviating from the standards that you're supposed to be following and that we expected you to follow. I'm sure you're not doing it intentionally. Maybe you say that at the outset, maybe not later in the process, but I'm sure you're not intending to do that, but I'm just telling you that's how we perceive it. The other, I think, step that you may need to take if something is really getting out of control with a mediator, either during the process or more likely when the process has ended, whether the case is settled or not, and that is ratcheting the concern up to the agency that the mediator works through, either JAMS or the AAA or many of the other great organizations around the country, or in certain circumstances, if there's a state bar for mediators that governs the conduct. If the conduct is truly egregious and not stopped through the process of conciliatory conversations and approaches, I think you ought to consider ratcheting up the process. The final point is, if the mediation is truly out of control because of something the mediator is doing or not doing, and you've gone through the other steps, I don't encourage parties to end mediations before they're done, but in a situation where the mediator has lost the faith and confidence of the parties, or at least of your party, it is not inappropriate for you to say, Madam Mediator, Mr. Mediator, I think we have to be done for the day. We're not getting to where we need to be, and I don't want to make the process worse already is. Bottom line, I tell everybody that the mediator's goal ought to be to not make things worse by the end of the mediation than they were when started. So assume the mediator's coming in good faith, give the mediator the opportunity to correct or address conduct they're concerned about, but then ratchet it up the enforcement range if you really have got a mediator who's gone off the rails. So just some comments and thoughts as to how to address those things.
Thank you, Deb. Let's go to difficult participants. But before I do, Florida has this fabulous case. It's called the Vitakis, Vitakis decision about a mediator that threw papers at people, demanded that people get real and start to settle this because he had to go home and be with his children, and just basically browbeat everybody. And whoever reads that opinion says, oh, isn't that awful? Well, I twice had mediators throw things at me in mediation. Maybe it's just Florida, but you have to be ready, and you have to be forearmed with what your rights are to protect the process and take somebody like that up, up the line if you have to. But let's move on to participants. So I once had a mediation where my opposing counsel stood up, leaned towards me across the table, and that horrible voice pounded on the table because we were being so unreasonable. So Deb, tell me what to do about less than courteous professional participants in a mediation, and who's responsible for maintaining peace and order when that happens. By the way, there's no questions. There's no one who has any ideas at this point or examples, so we can go on to the next one. I'm not ignoring anybody. Go ahead, Deb.
I think it is the mediator's obligation to control the proceedings as much as possible, and the mediator should not need to be told by the lawyers or the participants that the other side should stop acting out and you need to take control and whatever. So first point, I think mediators should be, you should be sure the mediator sets ground rules at the beginning. And I always do that. I'm sure Patricia does it in getting the mediation going. I explain the conduct that is appropriate. I explain why mediations work, and that everybody in the room is presumed to understand that you need to both talk and listen, that civility is important, and that conduct, sometimes I even say, especially if I have a little bit of history about either the parties or the lawyers, which I try to get ahead of time in separate caucuses from the lawyers, I think you get the mediator to set ground rules from the beginning. If the ground rules aren't being followed, I think, again, you're alert to it. I'm not a believer in every dog gets one bite. Sometimes you have to stop after the first bite and not let the second bite come. But I think you should engage the mediator's assistance in stopping that conduct, the condescension, the aggressive conduct, the bullying, the disrespecting of other people, either in tone or in words, and certainly misrepresentations. So first, start with the mediator. Pull the mediator aside if it's appropriate to do so and say, this is the conduct that's happening, whether it's happening in the main joint session room or it's happening in the hallways, which sometimes happens where a lawyer or a party is bullying or aggressive. I think you first bring it to the attention of the mediator. You make the mediator aware of the specific conduct. You call for a separate caucus, perhaps, with the mediator and the offending lawyer, if it's a lawyer, a little harder if it's a party or a principal, but you can do it as well. And participants in this process are supposed to feel as if the process is civil, fair, that they are to be heard and the other side is to be heard. You can follow the same admonitions with respect to parties and principals. Report the problem within the JAMS organization to the case manager in the case, to the AAA case manager, and say, just want to let you know, we had a party in this case who got completely off the rails and was aggressive and bullying. It was so problematic that, and then be prepared to tell the person within the protection of the confidentiality privilege what happened. Call for separate caucuses. You can, again, you can stop, you can adjourn, but you want to avoid that if you can. You want to keep the process going, but you don't have to accept inappropriate behavior. I think a more nuanced issue is, at what point do you really call out the offending party in the big group session? And although I always counsel, I counseled myself as a practicing lawyer, I counseled my clients to be reasoned and careful in the approach. Sometimes the conduct is so aggressive and so bullying that it's both strategically important, but also just important if you're the lawyer for your client to see this, if you're the client, for you yourself to feel like you didn't lose your control or your power in the process. Sometimes it's important to just call it out in the big group session. I wouldn't do that precipitously, and I certainly would tailor that to conduct, because sometimes people feel disrespected by even the most minor of things. I might think it's minor, Patricia might think it's not minor, or vice versa. Your client might think it's major and you don't think it is. So you need to be alert, I think, to the harm that's being done, the conduct and the nature of how inappropriate it is. But there are some things you should just not let go. And if the mediator isn't taking charge, then I think it's important for the lawyers and the parties to feel heard. Patricia.
Yeah, we're getting comments. Let's start with Michael Weber. Michael?
Hi, Patricia. Hey, I got to tell you first, it's really great to see you. It's been too long with COVID and everything else. So this is a real pleasure.
Thank you.
I chatted Patricia to let her know that I had a similar situation. I had an opposing counsel who was a table banger. He was threatening us with 7 figures in damages if we didn't do what they wanted to do immediately and settle the mediation. And I felt like he was putting on the theatrics in order to try to intimidate our client. And I wanted our client to know not only that I had their back, but that we were not going to be intimidated. So short and sweet response to the opposing counsel, I said to him, I wasn't bullied as a child, and you're certainly not going to bully me as an adult. And that was the end of the conversation. Right. We did not settle the mediation. The mediator, we didn't settle at the mediation. I'll leave it at that. We ended up in a 12-day arbitration, and we paid nothing. We won. So the message really, it's not always going to be the situation, but the message is, don't be intimidated by, we've all heard that expression, when opposing counsel starts banging the table, it means because they're short on the law and the facts. And
very good.
And there's really there's probably a lot to it. So, I think the message is, don't be intimidated, stand your ground if you've got a strong case. And, if the mediator isn't there to assist and facilitate and get it done, litigation goes on, and you'll get it done, through the course of litigation. So thanks for the opportunity to talk to you.
You're welcome. Jen Melander had an excellent question, which is, isn't it true that some parties hire mediators who will yell at people?
Oh, I used to say when I was practicing law, clients get the lawyers they want. I mean, just like one size doesn't fit all for a particular client to have a lawyer who is one way or the other, Same thing is true for mediators. And I do think some lawyers probably hire mediators they think are table bangers, they think are screamers and yellers. I didn't hire those mediators when I was a lawyer, and I'll go on record, I'm not that kind of a mediator, nor I suspect is Patricia. But yes, no, Jen, you're absolutely right. No question that lawyers sometimes choose mediators because of those particular skills, which takes me back to my beginning point, which is your job as a lawyer is to know the mediator's history and to know the mediator's approach to things. Not all mediators are right for every case. I'm not right for certain cases. I don't think I can do everything, and I don't think my style works for everyone. So doing that research ahead of time, and if you're the wonderful thing about mediation is nobody can force you to take a mediator. Sometimes you can be forced to take an arbitrator if the arbitrator doesn't have obvious conflict issues, or not, whether obvious or actual. But nobody can make you take a mediator. So do your research, I think, on those.
And Loretta, will you give your comment, please? Oh, well, Loretta's comment was that she doesn't care. She doesn't think it's appropriate to ever raise your voice, and you lose credibility and trust when you raise your voice. I happen to think that's true. So Tom, I think we are just about done. Is there anything that you want to say to round things up?
No, Tony just had a question. He says, what about if the mediator yells at you?
Okay, well, what do you think you should do if the mediator yells at you? I've had that happen. So what do you do? Yeah.
I think, what do you think, Deb? Yeah.
Yeah, I am trying to think if a mediator ever yelled at me. Yes, actually, I can remember a couple. And I was quiet and focused. I did not rise to the occasion, but that's my style. I simply looked at the mediator until it was a he, stopped talking. And I waited. And he said, okay, let me go back in the other room and blah, blah, blah. So you got to be true to yourself. And sometimes I've gotten aggressive over the years in situations like that, but not with a mediator who was yelling at me. I just stopped talking and I just look at the mediator like you'd look at a child who's having a tantrum and say, gonna wait till you're done. But again, I don't want to minimize. If the conduct is really egregious, I think you should call it out. I think it's important to call it out.
Tony, did you want to add to that?
Yeah, I had to call out the conduct because frankly, it was a very ineffective mediation that we were in hour 13 or 14.
Oh.
Yeah, by Zoom in front of a computer at 10:30 at night was not where I wanted to be.
No.
And so my frustration boiled over a little bit with the mediator as well. And so I mean, I think that's what it was, is a little bit of frustration, but the frustration came from both sides because the mediator was stuck because she wasn't getting anywhere with the mediation, and we were stuck because we weren't getting any offers. Like literally we were there 14 and a half hours and hadn't gotten money put on the table. And we're like, why are we still here?
You're more patient than I am.
Tony, what was the response, if you can share with us, when you kind of called it out and were aggressive back or responsive back? I won't say aggressive. Did it help? Did you get a kind of backing off? What happened, if you can share with us?
Yeah, the mediator did back off a little bit and kind of took the position. It was a female mediator, and she took the position that she was like, it's not like we haven't been trying in other rooms to get something out of this. It's not like we've been screwing around and things like that. And I was like, I understand that, but there's no need to yell at me when you can't get them to do something.
Right.
And that was fine. She apologized. I apologized. We went on our separate ways. We're fine. But it was just one of those situations where it was like, come on, really? It's 10:30 at night. We start at 9 in the morning. What are we still doing here?
All right, Tom, we've exceeded our time. It was such fun.
Yeah, thank you, Patricia. Thank you, Deborah. And thank you all for attending. Have a great day.
All right.
Hey, bye,
Bye, everybody.
Bye, Marilyn.